to meeting number 17 of the Subcommittee on International Human Rights. Today we meet to hear from our final witness in view of our study of the role of the Canadian Ombudsperson for Responsible Enterprise. To ensure an orderly meeting, I would encourage all participants to mute their microphones if they're not speaking and address all comments through the chair. When you have 30 seconds left in your questioning time, I'll signal you with this paper here. Interpretation is available for those that need it, French or English, through the globe icon at the bottom of your screen. Please note that screen captures or photos are not permitted. I'd now like to welcome our witness for this evening from Canada's National Contact Point, Director General Chris Moran, Trade Portfolio Strategy and Coordination at the Department of Foreign Affairs and International Development. Ms. Moran, if you have any opening remarks, I now invite you to make your opening statement for up to 5 minutes. Ms. Moran.
Thank you, Mr. Chair. Good evening, Mr. Chair, Vice Chairs, and members of the committee. Thank you for this opportunity to assist the committee in its work. Before I continue, I would like to acknowledge with humility that I am participating in this meeting from Ottawa, which is situated on the traditional and unceded territory of the Algonquin Anishinaabe people. And I acknowledge the history of Canada's settlers, and I recognize the continued impact of colonization on all Indigenous communities. I am here today in my capacity as the chair of Canada's National Contact Point for Responsible Business Conduct, which is one of Canada's 2 dispute resolution mechanisms for issues related to Canadian companies' actions abroad. The NCP is one of many instruments that reinforce Canadian policy in this area, and I take this role very seriously. The National Contact Point, or the NCP, is a federal interdepartmental committee mandated to promote the uptake of the OECD guidelines for multinational enterprises, or the M&E guidelines as we call them. The M&E guidelines were originally drafted in 1976, but they took on a greater prominence in late 1999 in the face of heightened sensitivity to globalization and the important role that companies play. The M&E guidelines are the only multilateral code of responsible business conduct that governments have committed to promote, and they are periodically updated to ensure that they are fit for purpose. For example, the OECD has developed additional guidance documents for high-risk sectors and has most recently published guidance on due diligence to assist companies and NCPs. In 2000, all OECD members, including Canada, committed to establish NCP offices to further the effectiveness of the guidelines. Canada's NCP, therefore, is one of a global network of 50 national contact point offices. The NCP network meets regularly to share best practices, collaborate on cases, and to develop forward-looking policies. NCPs provide a place where everyone from individuals to communities to companies to civil society can bring their concerns. Each NCP provides voluntary, non-judicial mediation and conflict resolution to address issues that arise between these groups. Cooperation amongst network members ensures that there's consistency across all NCPs and how cases are treated. You'll recall I said a moment ago that Canada's NCP is an interdepartmental committee. It was established through an order in council in the year 2000, and it comprises officials from 8 departments: Innovation, Science and Economic Development, Natural Resources Canada, Finance, Environment and Climate Change, Crown Indigenous Relations, Employment and Social Development Canada, Public Services and Procurement Canada, and of course, Global Affairs. This makeup ensures that our NCP has the relevant expertise to review complaints under any of the chapters of the M&E guidelines, which address a range of issues such as transparency, human rights, labor and industrial relations, environment, and due diligence. And the M&E guidelines are sector agnostic. As such, the actions of any Canadian company in any sector can be considered, provided the company meets the definition of a multinational, which in its simplest terms means that a company operates in 2 or more countries. And as I mentioned, like all other NCPs, Canada's NCP is a voluntary non-judicial grievance mechanism, but we do stand apart. And that's because unlike the other NCPs, Canada's NCP has an important tool to strengthen our effectiveness: the ability and the willingness to withdraw government trade advocacy support and to recommend that EDC deny future financial support if the NCP does not find that a company has acted in good faith. We call this the trade measure. In fact, the International NGO Consortium, OECD Watch, has recognized this important consequence as a best practice that other NCPs should emulate. Since 2000, Canada's NCP has reviewed 20 complaints, 7 of which were received in the last 3 years. The majority of these cases, 85% of them, were in the extractive sector, and 2/3 were filed by NGOs. We are currently reviewing 4 cases, of which only 1 is related to extractives. Canada has also supported other NCPs in 10 cases involving Canadian companies. Positive outcomes of NCP cases can include trust building between the communities, workers, and companies, remediation, longer-term policy changes within companies, and transformative learning opportunities for the parties. The NCP has a dual nature in that it works to promote the adoption of the guidelines by companies, to raise awareness with a focus on prevention and proaction to ward off potential problems before they do occur. It also aims to find solutions when problems occur. As a non-judicial body, the NCP does not render rulings on guilt or determine damages. The NCP provides an avenue to arrive at mutually agreeable solutions. However, the NCP does make recommendations, including with respect to the use of the trade measure. Before I close, I want to reiterate that the NCP is committed to responsible business conduct by Canadian companies and is working alongside the Corps to implement her important mandate. Thank you very much.
Well, thank you, Ms. Moran. Right on time, and we are going to now proceed to questions from the members. We're going to begin with, from the Liberals side, we've got the Honourable John McKay for 7 minutes.
Thank you, and I apologize, Chair, for my challenges of getting onto the site here, but it is what it is. Can I ask the witness, did you say that since 2000 you've had 27 cases?
We have had 20 cases.
20 cases since the year 2000?
Yes. We are currently reviewing.
1 case per year?
It averages out to 1 case per year, yes.
Not overly burdensome, is it? I kind of find that surprising, since it seems to me that there's a lot more complaints than 1 case per year. Now, you said that there are representatives of various departments, natural resources, finance, foreign affairs, et cetera, et cetera. What is the representation of the complainants themselves, the people who have grievances with mining companies who do bad things?
For the most part, 2/3 of the complaints have been brought forward by NGOs. There are instances where they have been brought forward by an individual, or in some cases, they could be brought forward by a company. But the majority of our cases have been brought forward by NGOs.
So you have the majority of the cases, 1 case a year really, brought forward by an NGO, actually not even 1 case a year, brought forward by an NGO somewhere in the order of once every 1 1/3 years, 1.5 years, an NGO brings forward a case, and yet it doesn't take a genius to work up that there's a lot more complaints about particularly Canadian mining companies than 1.5 cases per year. So why would it be that the NGO community is either quite reluctant or doesn't wish to use the national contact point in on a more frequent basis than once every 1.5 years?
Well, Mr. Chair, what I can say is that this is a voluntary mechanism, and we stand ready to receive cases. There is a dual nature to the NCP, which is both promoting the uptake of the guidelines, as well as promoting the use of the NCP mechanism, at the same time providing the good offices and the dispute resolution. With respect to the question on why, I cannot answer that with the fact that it's a voluntary process. We stand ready to serve any complaint that comes to us.
We have a voluntary process where you promote the use of the NCP mechanism, and it only gets used once a year, even less once a year by the NGO community. Have I got that right? Am I missing something here?
You have that correct. It is a voluntary mechanism, and we do not have the ability to initiate cases.
So we've been going through these hearings, and we've heard a lot of complaints about particularly the extractive sector, but more broadly than that. And in the last while, it's been felt necessary that we set up the core. Mm-hmm. So if you're only doing one case a year, and there's a lot of people seem to think that the core is a necessary organization, what is it that you're going to be doing that the core can't already do?
So there are differences between the two offices. The core is the latest demonstration, and I would say the latest commitment to ensuring human rights are respected abroad. So the core's mandate is really focused on key sectors, and it's focused on human rights abuses, as I believe you will have seen the mandate.
Your organization is not focused on human rights?
The national contact point is aimed at promoting the NCP guidelines, the MNE guidelines under the OECD, which covers a range of issues that could include industrial and employee relations, transparency issues. It could cover due diligence, environment. It has a broad range of issues related to responsible business conduct.
But you'd have to agree that the large volume of complaints are human rights complaints, are environmental complaints, and really you seem to be focused on things that people are not complaining about, with greatest respect. Is that correct?
As I noted, Mr. Chair, the NCP has a dual mandate to promote at once the guidelines and to provide the good offices. As a voluntary mechanism, we receive the cases that we receive.
And have you ever made a recommendation on any of the cases since 2000, the last 27 cases have you done since 2000? Have you ever recommended that either financial support or consular support be withdrawn from any company?
Yes, Mr. Chair, we have. The NCP in 2014 recommended that the trade measure be adopted against a company called China Gold.
China Gold. Mm-hmm. And so that's one company, one case in 20 years. Is that fair? I mean, I'm just asking.
It is fair, but it's also important to recognize for context that the use of the trade measure is intended to incentivize good behavior, and we use it sometimes during the course of a request for review. So in conversation, we are very clear with companies that this is a consequence should they not engage in good faith.
Thank you. Thank you. And so we'll be moving now to the Conservatives for 7 minutes. And Mr. Reid, you have the floor.
Thank you, Mr. Chair. To our witness, I hereby pledge to be less hostile than Mr. McKay, which is, I suppose, damning myself with faint praise. I wanted to ask a couple of things, if I could. Mr. McKay's questions imply that the problem is that your organization is just ineffectual and leaves the impression that it could not be made more effectual, which is, I think, the more appropriate way to handle this question. So I just want to ask, you aren't able to initiate your own investigations. You have to wait for complaints to be made. And it sounds to me, but you can correct me if I'm wrong, that investigations can only be undertaken against companies that have undertaken to comply with your guidelines. Is that correct? That's the starting point, that it's only companies that have already gone in and made the commitment that will comply with your guidelines that can be investigated?
That's not entirely correct, Mr. Chair. The Government of Canada expects that all Canadian companies operating abroad will abide by the guidelines. And so there is promotion to ensure that they are aware of those.
Okay.
That's the starting point.
Sure. So, but I think I'm still right. I may have phrased it inexpertly, but am I right that any company that undertakes the assistance of EDC effectively in so doing has undertaken as a kind of part of the terms of service to abide by these guidelines?
Export Development Corporation does have its own, it's an arm's length body, and it has its own ESG and RBC framework, fully consistent with the guidelines. But I cannot speak to whether or not they are specifically requiring that. What I can say is that the Government of Canada, through the Trade Commissioner Service and Global Affairs Canada, does impress upon Canadian companies the importance of abiding by all laws locally, as well as the NCP guidelines, the MNE guidelines, excuse me.
Okay. Our hearings are into the ombudsperson, as you know, and the ombudsperson's ambit or province or area of jurisdiction includes extractive industries, it includes the textile industry, and it excludes some others. So the obvious thing I note about these is textiles is all about importing something into Canada, which has its origin abroad. Extractive industries are a bit different. Their goal is to use Canadian companies to actually engage actively in the process of extraction. I'm just wondering, given those two kinds of categories, and I think you can see the clear distinction, where you find the issues are tending to arise, in which industry sectors that you're dealing with. That's relevant because one of the claims that's being made is that the ombudsperson's area of jurisdiction ought to be expanded. And the question I have is where would one look? Where are the problems based on your own experience?
So, as I noted, the majority of our cases, both dealt with by the Canadian NCP, as well as those that we have assisted, are in the extractive sector.
Okay. And I mean, one of the reasons that might be, I just want to pursue this a bit further. Does it strike you that this is in part because of the fact that the extractive sector is so important and is such a large proportion of Canadian investment abroad, or is it disproportionate even when that is taken into account?
I'm sorry, Mr. Chair, could I ask that the question be repeated? I'm not sure.
Yeah, I'm sorry. I'm not sure. I think the problem was not my microphone. It was my way of putting it. So let me put it this way. A very substantial proportion of Canadian investment abroad is in resource extraction, right? So you'd expect, all of the things being equal, for an equally large proportion of cases to be from that sector. I'm asking whether it's more or less what you'd expect, or whether there are additional problems that indicate that the sector itself is the one that is considered by the NGOs who make these filings to be more problematic than other industries.
So ours have majority of our reviews have focused on the extractive sector. Mm-hmm. That has to do with a number of factors. Extractives are by nature adjacent to communities. There's more opportunity for there's more opportunity for interaction, for conflict. There are a number of factors at play.
Indigenous land right issues strike me as being one that would be in play with that sector more frequently than with anything else except maybe forestry.
Perhaps it would be my guess as well.
Yeah. Okay. Okay. You indicated 20 cases have been undertaken. I assume you receive complaints, look at them, and in some cases say this simply can't be pursued, or it either doesn't have merit, or the nature of the evidence provided is it's inadequate, or something like that. So 20 being the number of cases you've looked into, how many would you say have actually come in over that 20-year period? Or what proportion do you pursue? There's some way of answering that. I'll leave it to you to figure out the right way of getting that back to me.
Thank you so much. In fact, in order to ensure that there is transparency, that NCPs are operating transparently, it is not possible to receive a request for review and not treat it. So okay. There is always a report that's issued. And so that 20 does represent the range of them. And okay. As I noted, we have 4 ongoing right now.
Okay, so it's 4. So that suggests then that unless they've all bunched up and been given to you in the last year, that it's not one a year, that there have been a period of relative quietness. And it sounds either like it's getting busier now, or alternatively, that these investigations may take several years to complete, or some combination of the two.
We do aim to abide by service standards, but some of the cases do take longer to resolve than others.
Right.
Thank you, MP Reid. Now we're going to be moving to the block, and Monsieur Alexis Brunel.
Mr. Alexis Brunel-Duceppe, 7 minutes. Thank you very much, Chair, and thank you very much for being here, Madame Morin, with us this evening. It's important for us because this is our last meeting, and it's important. It's my study. I'm just saying. It's important for you to be here this evening because the NCP really isn't very well known. I just want you to confirm something that was said earlier, and I come back to Mr. McKay in the Liberal Party. Do you think that it's time to have the installation of the ombudsperson? It's high time.
Thank you.
Mr. Chair, I'm going to give you all this time that is being lost in transfer.
It is, the appointment, the establishment of the CORE is an important step forward with respect to Canada's commitment to human rights by Canadian companies operating abroad. There are important distinctions between the CORE's office and the NCP. As I noted, the ability to initiate cases is one very important distinction.
Okay, but earlier it was mentioned that, in fact, the problem was these complaints are voluntary. So the process that is required, well, you have to put yourself in a situation of danger before you can actually address the PCN. And it's the same thing with the ombudsperson. According to what we've heard from the beginning of our hearings, the power of inquiry. Do you think that it can only go through the ombudsperson?
Minister Ng's comments at the committee on the 23rd of March, where the minister did indicate that she believed that the Canadian ombudsperson does have the tools and instruments that she needs to be an effective mechanism.
Okay,
Perfect. Okay. Earlier, we talked about defending human rights, but some of Minister Ng's opinions weren't shared. You spoke to us about responsible practices. You said that it was very important for you, and I sincerely believe you. Do you think that mining companies really compete to be the most responsible amongst themselves? In view of the fact that you look at that, I should think that you would be well placed to answer my question.
First of all, Canadian companies are recognized the world over for the fact that they are law-abiding and for many steps that they've taken towards voluntary processes. I believe that you have heard from the Mining Association towards sustainable mining, but there are other examples. I would note the Chemistry Association developed responsible chemistry, and that has been adopted by, I believe it is upwards of 70 countries.
But no, do you have some examples of mining companies some concrete examples of responsible behavior amongst them? Since you're promoting that, you must be able to give us a concrete example.
In the NCP, so at once we are looking to promote the uptake of the guidelines. We're working very closely with Canadian companies. And as the NCP, I would not hesitate to reach out to a company to initiate a conversation about the guidelines, even if it was not a case that was referred to me formally by an NGO. So we're monitoring the situation. We're also working with Canadian embassies overseas. The NCP is part of a broader policy framework. We have initiatives related to natural resource governance, on the foreign policy and development assistance side. And the NCP is one of those many policy instruments.
Est-ce que vous avez entendu?
Did you hear anything said about the mining company, Ferroterra? What do you think about it?
I do not know much about Frontera.
Mais là, vous venez de me dire que...
Yes, but you've just said that you've heard about it. But you don't know much about it, or I guess in your position that you should be an expert, and you are an expert in this matter. I imagine the government is paying people to be experts, and they should know what falls into this area of jurisdiction. This is your field of expertise. What do you think about Frontera?
What I can say is that I follow the committee discussion very closely, and I am asking questions about Frontera right now.
OK. Et donc, vous...
Okay, but you didn't ask any questions before you saw what the committee was doing.
Donc, Frontera, pour vous, c'est...
Frontera, then, for you, is something that you didn't know anything about before the committee opened up its consideration of the matter. Is that right?
I was not aware of the specific issues that were being raised before last week.
OK. Et vous savez...
Okay, and you know that Frontera is an enormous problem right now. But you've just said, you're telling us that you only learned about it last week when we were carrying out our study. So logically, you are admitting that the NCP and the ombudsperson don't have enough power to confront Frontera. That's what you're saying, isn't it?
Mr. Chair, the NCP is a voluntary mechanism that has a dual role to both promote the uptake of the guidelines and to receive cases and provide voluntary remedy.
Juste pour vous dire...
Just to say, Madame Morin, I'm not being personal. This is not personal at all. I just want to help the NCP and the ombudsperson to be better placed to be able to react to Frontera, which presently constitutes a huge problem. It's a Canadian mining operation, and I think that you should have more power to be able to act. I know I've only got 30 seconds left. This is nothing personal. I just want to seek to understand that why you didn't know about the Frontera problem before last week, and now, if you had, maybe you would have been able to act well before that. Thank you, Mr. Brunel-Giuseppe.
Now move to the NDP for 7 minutes, and Ms. McPherson.
Thank you, Mr. Chair. And I want to thank Ms. Moran for joining us today. I agree very much with my colleague from the bloc who is expressing what I was thinking, that we are really trying to find a way to make sure that Canadian companies are being held to account, and that the good Canadian companies, particularly good extractive companies, are not punished by the bad behavior of other companies. So really, this is us trying to get to a place where we can report to the government on what we'd like to see. It's not meant to be an attack on anyone. It's certainly not meant to be an attack on any government even. We have seen the NCP was put in place before the Liberals became the government. In fact, it was in place under the last administration, and I think it's important that we recognize that since the year 2000, there has been a number of different administrations that have been the government in this country. However, I do have concerns very similar to my colleague, Mr. McKay, about the fact that there are 20 cases that have been brought forward, that you have been in the position for 21 years, or that the NCP has been acting for 21 years, and that there are 20 cases, and 4 of them are still outstanding. So I guess what my further question to that would be is that how many times has there been remedy offered through the NCP? How many times has remedy been provided?
So it's important to recognize that the definition of remedy can vary depending on the complaint. And the idea of the NCP is to bring about longer term policy changes to find mutually agreeable solutions and to ensure that the parties are collaborating.
So has any remedy been given regardless of the definition of remedy that you're using?
Well, we have resolved cases to mutual satisfaction, and I would note that when we do not have, when we have a recommendation, the NCP follows up on the recommendation to ensure that in most cases it's the company, but in looking at policy changes and ensuring that those recommendations have been heeded.
And I just want to be clear, when you say mutual satisfaction, that is mutual satisfaction with the company and the NCP, the company and the impacted community, the company and the CSO or NGO?
It's between the parties, so between the company and, which is what we call a notifier, and the complainant.
Okay, because I have a 2015 OECD Watch study that says that there's only been 3 cases worldwide since 2000 that have resulted in what they describe as remedy, and that in fact none of those cases have been in Canada. So is that's not your understanding of where the NCP has landed? Is that correct?
I am aware of those cases, and what I would note is OECD Watch is looking for a certain type of damage. However, we have resolved cases that have been brought to us.
A certain type of damage. Okay. I don't really know what that means, but I'm gonna carry on if I could. One of the other lines of questions I think it would be important to find out about is how do you actually coordinate with the CORE ombudsperson? What does that look like, the NCP and the CORE? How does that happen?
So the CORE has just established her office, as you know. We have been working closely with the CORE to establish procedures which would allow both the NCP and the CORE to share information and, where necessary, to refer cases from one entity to the other. The procedures of both are established, and we're looking for complementarity between them.
So over 20 years, you've had 20 cases that you've expanded. The CORE, of course, has not had any to date. Mm-hmm. And you will work together. You will work closely together on coordinating how you deal with the cases that come forward. Is that correct?
Yes, we are working actively on that.
And do you feel that may put some risk to the independence of the CORE ombudsperson, that it may, in fact, either make her lack the independence that she should have, or certainly give the opinion or the perception of a lack of independence?
The CORE has been established to advise the minister directly, which is different from the NCP. Yet we have been asked to complement one another, so to work with complementarity. We would like to be able to refer cases to the CORE where they are falling within her mandate, and I believe that the CORE may receive cases that would fall outside her mandate but could be referred to the NCP. So we're working on how we can ensure that those procedures are complementary and that they are not creating additional burden for a complainant.
Thank you, Ms. Moran. And I mean, there's so many questions I'd like to ask you, and so much information I'd like to get. But I guess one of the things that we heard last week that I found most disturbing is that we heard from impacted communities. We heard that they were not going to come forward to the CORE because they did not feel that the lack of power to compel testimony, the lack of power to compel witness, meant that it would actually be worse for them. And we've actually heard from other impacted communities that coming to the NCP has actually left them in a worse state because they've used resources. They've used, relatively limited resources, of course. They've endangered themselves for very little result. What would you say to those impacted communities that are watching a Canadian company come in and ruin their climate, ruin their environment, break their laws, destroy human rights, and yet they don't feel that it is worth their while to come to either to the NCP or to the CORE ombudsperson?
What I would say is that I would encourage those NGOs to consider the NCP. I know that
not the NGOs, the impacted communities, the actual people impacted. Sorry,
and the impacted communities represented by usually by groups. I would ask them to consider working with the NCP to resolve those issues.
Can you tell me, have you had any interactions with impacted communities, with direct people who have been directly impacted by Canadian extractive industries?
Yes, I have.
Okay, thank you. Mr. Chair.
You cede your time?
Oh, do I still have time?
Well, you had 20 seconds. So we're moving to the second round right now.
I'll get it in the second round.
To Ms. Moran and to members, we're moving to the second round. The second round, just looking at the time, it'll be 3 minutes per questioner, and we will begin with the Liberals and MP Sidhu for 3 minutes.
Thank you, Mr. Chair, and welcome, Ms. Moran. Nice to see you here. Ms. Moran, beyond the role of CORE, what other responsible business practice measures does Canada have?
So the CORE is the latest in our commitment to responsible business conduct. The NCP, as I noted, is another non-judicial conflict resolution mechanism. But again, we are part of a broader framework. So there are many policies, and in fact, there are some legal instruments as well that exist. So I believe you're aware of the Corruption of Foreign Public Officials Act, as well as the change to the customs tariff. There are many other policies as well, which underscore and which really reinforce that expectation on Canadian companies.
Thank you for that, Ms. Moran. And how do you work with Canadian businesses to promote or ensure good practices with the business community?
Mm-hmm. The NCP is housed at Global Affairs Canada. And as you know, Global Affairs Canada operates embassies abroad. So we are working with our colleagues on the development side, foreign policy side, as well as trade promotion. So we're able to leverage all of the knowledge there. We are working with Canadian diplomats prior to their posting abroad to emphasize to them the importance of these issues to Canada, and also to make them aware of the expectation, the mechanisms, and the various tools that are at their disposal.
Thank you for that. And you know, how does the NCP case review process work? I know you touched on that in your opening remarks, but I'm hoping you can provide some further insights into the NCP case review process.
Mm-hmm. So the NCP, as a voluntary process, we abide by OECD procedures. So we are, as we committed to do, we have signed on to operate an NCP that aligns to the procedures established. We receive a complaint. It's called a request for review. We work with the complainant to ensure that the information is complete, that we understand the situation. We then reach out to the company, indicate that we've received this, and ask them to respond. Following an assessment to consider the facts in the case, we examine whether or not we believe that the guidelines would be furthered by offering conflict resolution. It is an iterative process, and we aim to ensure that we are receiving information from both sides.
Thank you for that. And Mr. Chair, how many seconds? What, 20 seconds?
20 seconds, that's right.
Okay, well, I'll just take this opportunity to thank Ms. Moran for her time today, and it's great to see everyone this evening.
Well, thank you, MP Sidhu. And now we're moving to the Conservatives and MP Gray for 3 minutes.
Great. Thank you, Mr. Chair. And thank you for being here, Ms. Moran, and thank you for the work that you do. And thank you for the information that you gave, going into more detail about, your roles and authorities. And it does sound like there's a lot of crossover with CORE, although there are some differences. Had the government given you the opportunity to expand your mandate?
Our mandate is quite vast. The MNE guidelines that are published by the OECD covers a very broad range of topics. I listed some in my remarks, but there are others. And I would note that the guidelines are sector agnostic, so they're not specific to any one sector. The CORE, on the other hand, is really focused on human rights abuses in a few sectors where we see greater risk. We are working alongside with the CORE to implement her important mandate, and we will continue to do so.
Okay. At a previous meeting of this subcommittee, the Chamber of Commerce testified about the extraterritorial issues and the difficulty in compelling testimony from subcontractors abroad, and that in some jurisdictions it would be a difficult proposition. Will the Corps be able to compel these subcontractors, or is it still the case that these might fall through the cracks?
So the Corps is a voluntary mechanism, and she will be working with Canadian companies. There is an expectation, there's a commitment from Canadian companies that they will work with her in good faith.
Okay, I think you touched based on this a little bit in your opening statement. Compared to other countries, where does Canada stand when it comes to corporate social responsibility? Like, does Canada generally have stronger measures or requirements on human rights compared to our peers?
Generally speaking, Canadian companies are recognized the world over, and Canada is seen as being a good player. We are recognized at the OECD for the strength of our framework. We do not solely have a promotion role related to the MNE guidelines. There are a number of other policy instruments and coherence measures that we have undertaken, which really speak to and underscore that commitment.
So while the Corps' goal is to look at human rights abuses after they happen, what can be done to prevent them before they happen? And I guess it goes back to my earlier question as well, looking at these subcontractors, because it did sound like you were sort of alluding to the fact that they would fall through the cracks. So can you maybe go into that a little bit more in detail with respect to being proactive?
In about 10 seconds, please.
Okay, so what I would say is that the OECD recognizes that companies, not just Canadian companies, any company has leverage in a supply chain, and due diligence efforts should extend to suppliers and sub-suppliers. I hope that answers your question.
Thank you, and Ms. Gray, thanks for joining our committee today as a sub. And now we're moving to Monsieur Alexis Brunel.
Thank you very much, Chair. Am I mistaken, Madame Morin? But the Office of the NCP wants to offer mediation, full stop, if the company wants to participate.
So the Canadian government does have an expectation that Canadian companies will engage in good faith with the NCP. Where a company is not engaging in good faith, we can recommend the use of the trade measures. So we can recommend the withdrawal of enhanced trade advocacy support, or we can recommend, and I would say, we could recommend sorry.
Pardon.
No, I'm sorry too. I'm sorry. I'm the only francophone, so I have to get a lot in quick. Do you think this is in good faith or in bad faith?
I'm sorry, I'm not sure what you're referring to.
You say that if a company refuses in bad faith, are you the one who decides whether or not the company's in bad faith or not?
The NCP would make that determination. The NCP has, and I have used this myself, I have had conversations with general counsel and presidents of companies when I do not consider that the companies are engaging in good faith.
Okay.
So I would say it is a very powerful discussion.
So, for example, we were told last week there was an example of a business, a Canadian one, that they refused to do business according to the Mexican rules, and the Mexican president felt that they had not respected Mexican law. Could the NCP be a mediator if there was this lack of cooperation on part of the Canadian country? Then what would happen? Because here we're talking about Mexican law, and that could have been in good faith.
C'est pas long, 3 minutes.
3 minutes isn't very long. Chair? just be advised that with translation, it takes some time for the message to pass. It's not Madame Morin's fault, but sometimes there are some delays in the translation, up to 20 seconds. So 3 minutes with a translation should be a little bit longer than that. You're very aware of that, Mr. Member? Okay, I'll let Madame Morin answer my last question.
So, Mr. Chair, if that issue was to be brought to the NCP, we would examine the facts. We would certainly make an offer of mediation or good offices. We have to take into account all of the factors, including the fact that there's an NCP in Mexico as well. So we would be looking to collaborate with our peers.
But overall, thank you very much. Thank you, Mr.
What we
Monsieur le Président, ce que je vais faire, Monsieur le Président, pour de vrai,
from the NDP.
Écoutez-moi.
Listen, on a point of order, seriously, I'm going to calculate the time for my last turn. Oh, no, thank you.
Yeah, okay, Monsieur Bernal Giuseppe, I do have a timer on it, but we will now move to the NDP and Ms. McPherson.
Thank you, Mr. Chair, and thank you, Ms. Moran, again for being here. So I'm really struggling to understand how the NCP is different from the core. We have an NCP who can review, can mediate, can advise companies. How is this different than the core?
So thank you, Mr. Chair. I would note that there are a couple of key differences. So first of all, the core is established to be somewhat distinct from the department. That responds to a key concern.
But you've already said that you actually interact quite closely. So
we are working to collaborate. We are working to collaborate. The core has been established to provide advice to the minister directly, as well as the fact that the core has been established with her own budget. So she is not reliant on departmental resources.
An increased budget from that we heard last week. So I just want to be clear, and I know I have very little time, so I know I seem rude, but so we have a NCP who's been in place for 21 years, less than one case per year. We have a core ombudsperson in the role for 3 years, no investigations. We have Indigenous and impacted communities who will not come forward to Canadian Ombuds people, whether it's the NCP or the core. We have two organizations that do essentially the same work. Neither have the ability to compel or compel witness or testimony. In what way would Canadians feel confident that their name is not being tarnished, their reputation is not being tarnished around the world when we have very little remedy available, that there is very little that you are providing for organizations or individuals that are impacted by Canadian mining. We heard last week from Canadian Mining that said scrutiny was the biggest impediment to their success. And it seems very much like the government listened to the mining companies and in fact made sure that there was very little scrutiny. How do I go to impacted communities and tell them differently?
So it's important to recognize that the core and the NCP are both part of a larger framework, that there are efforts across foreign policy, development assistance, human rights promotion, etc. And that this is just one of the mechanisms. The core is the latest in the government's commitment to human rights abroad.
You'll forgive me if I say, though, that it seems like we had one tool that was very ineffectual. Now we have two tools that appear to both be ineffectual. So saying that there are more tools that are equally ineffectual does not seem like a particularly strong response to people who are losing their drinking water, for communities who are sick, for people whose human rights are being, people are being murdered, and Canadian companies that are acting in good faith, good Canadian companies will suffer. Our reputation as Canadians working around the world will suffer. So I don't understand.
Thank you. And that is our time. I do want to thank Ms. Moran, our witness today, for answering so many questions so succinctly. Thank you for the time. We appreciate it. And members, we are going to now suspend before coming back in camera in about 5 minutes. Thank you.
Merci, Madame Moran.
Thank you.